sufficient facts as stipulated to by Mr. Kalema in 2006 that there was commission of the crime of driving under the influence and driving while suspended in the third degree. So I'm going to enter the finding of guilty on both of those counts. Now, in the 627 case, possession of marijuana, use of drug paraphernalia, this predates the initiative in 2012, which retroactively decriminalized those offenses. So I think Mr. Compton, you were raising Blake, because I think that's even a separate issue. But Mr. Thompson, is there any, from the state, is there any other point of view on the issue of the retroactive decriminalization?
No,
yeah, I think that one we just, I mean, that probably should have been done a while ago, but we just never reviewed the case before. So both counts of 627 are dismissed. So at this point, then, we need to proceed to sentencing on 626, both counts, and address any probation violations on the C24354 TC. So Mr. Thompson, I'm going to ask the state first for your sentence recommendations on the revoked deferred prosecution.
Thank you, Your Honor. This case poses an interesting issue in that when looking at his criminal history, if we were back in 2009, when the defendant got his Tacoma Municipal Court DUI and we're addressing this as probation, I have no doubt that the court probably would have heard from the state to impose the entire balance of this case. It was his fourth DUI in a 5-year period that he just got convicted of while on a deferred prosecution. And I frankly wouldn't be surprised if the court had followed that recommendation at that time. And the state, to a degree, is inclined to ask for that again. Although I will acknowledge that for the last 14 years, the defendant has kept his nose clean. And frankly, that's the only saving grace I can say for the defendant here, is that in the 14 years that he's been absent from this court, or nearly 14 years he's been absent from this court, he hasn't really done anything up until May of this year when he got arrested on the suspended third case, or cited on the suspended third case. I don't feel mandatory minimums are appropriate. Although I would understand if the court did impose mandatory minimums based off some of the reasons I just talked about. But as I said before, this is an individual who committed 4 DUIs in a 5-year period, and then absconded from responsibility for addressing it. I think it's important to note at the history of this case, this isn't he was into his deferred prosecution, he completed his treatment, and then had a criminal charge. The facts of the case are very, very different. If I remember right, there wasn't much done in this deferred prosecution. Go back to a note here. I didn't see much in the way of any treatment that was ever filed in this case. And it's possible, given the age of the case, that I missed some of it. We attempted to recover various aspects of the case files on one of the other older cases, and not everything I think was found. But the fact that he got subsequent convictions back in 2009 and then disappeared from this court's jurisdiction for that time is concerning. The state's asking the court to impose 180 days in custody on the revoked deferred prosecution and 120 days on EHM following that. And on the probation matter, we'd ask for an additional 90 days.
Mr. Compton?
Thank you, Your Honor. I understand the state's position. Mr. Kalam was in a very different place in his life back in 2006 through 2009. In my conversation with Mr. Kalama and Ms. Callahan's conversation with Mr. Kalama, his life has been marked by a tragedy and a lot of struggle. We filed his wife's certificate of death with the court, along with a number of letters in support, including from his 16-year-old daughter, who is his dependent and who lives with him and relies on him for, and now that her mother is gone, for all of her support and the continuity of her life moving forward. Mr. Kalama, admitted to the 2009 DUI in court when we were here, I think 2 times ago, is not willfully trying to hide anything from the court, has come back to address these now that he's aware of the issues. I believe he did attempt to get through treatment back in 2006 and 2007, but I believe from reading some of the revocation requests that were provided in discovery, I think the issue wasn't that he wasn't complying with treatment, but the treatment was not a certified agency, so he was going through a tribal agency rather than through a state certified agency. I think that was part of one of the underlying issues of the deferred prosecution revocations that came before the 2009 DUI, and I just don't know if it was ever addressed. I recognize that he's been found guilty, that the court is going to impose a sentence, but I would ask the court to consider, he has had 14 years of sobriety at this point. He's working. He's got a daughter to think of and take care of. And if the court puts him away for 180 days, it's unclear what's going to happen to his daughter, who either wasn't, or I don't believe she was born when he entered the deferred prosecution. And so my request to the court would be that the court consider the whole picture of his life and not just his criminal history when sentencing him. And in terms of the nuts and bolts of his sentence, from the 2006 era sentencing statute that would be in force and effect with this sentencing, I believe as far as I can tell, is it a DUI with one prior offense within 7 years? I don't believe the 2009 would count because there was no relating forward provision.
No, there were 2.
2 from before?
Right, within the look back period.
Okay. And I would ask the court to consider allowing him to do an extensive period of electronic home monitoring as an alternative, just for the benefit of his child, so that she doesn't lose both of her parents, and allow him to serve whatever portion of sanction court orders. He's a mandatory 30-day sanction minimum on the probation matter. Allow him to serve that as electronic home monitoring entirely, so that he can continue to provide for his child. I believe he requested, if the court is going to impose a jail condition, if the court could put him into Nisqually jail, so that he can serve closer to his family and his support system. I totally understand that he has a significant history and that he has significant minimums that he has to meet. But I believe that under the sentencing statute, the court can, convert the mandatory minimums in the event that there is a significant, mental health or physical health concern with imprisonment or confinement, a substantial risk to the offender's physical or mental well-being. I think the concern here is not necessarily for the offender's physical or mental well-being, but for his child's welfare. I believe the court can make that finding, and I would ask the court to impose a sentence on Mr. Kalama that will allow him to continue to parent his child, to prevent her from, losing both parents essentially for a period of time, and still allow him to function. I believe Mr. Kalama has some things he would like to say. I believe you prepared a statement. Is that right, Carl?
Yeah. Mr. Kalama, what would you like to say?
Well, I just want to say thank you guys. I know what I've done, and the things I changed in my life is to the good because of my family support that I have. I did have a lot of, things with my wife that happened, and I understand alcoholism is very bad, and I don't want to put that on anybody. I changed my life from the time I been in jail from Tacoma. Probably the reason why I didn't do that because I understand that taking care of a family is a big thing and support, and I didn't want to lose my kids. But I'm here now and I'm ready, and I appreciate it. I forgot my paper, but I just want to say thank you, and I'm willing, I'm ready for whatever happens.
May the state respond to the alternative jail option?
I think I know what you're going to say. Go ahead.
Thank you. Obviously, the state would oppose that. But I do want to point out that I don't know if that was an option in 2006. Frankly, I didn't research that part. But if the court looks through some of this, if the court looks through some of the historical iterations of the DUI sentencing grid, it wasn't until recently that the sentencing grid has been expanded to beyond the second DUI. Historically, it was only available, the alternative was only available as an option on the second DUI.
Yeah, it also doesn't allow for a exception to total confinement on the basis of the anyone other than the defendant, him or herself. So
agreed.
I mean, that's just a legal limitation there. So okay, yeah, and Mr. Kalama, this is tough because, as Mr. Thompson pointed out, as Mr. Compton pointed out, this all happened a long time ago, and you went through a process here to try to deal with these cases with the deferred prosecution and with probation, and that just utterly failed. I mean, there's no question about it, right? You got another DUI, and I don't know what punishment you got for that, but you did.
Yeah, I spent a significant amount of time in jail.
Did you?
Yes.
And that would be not surprising, given your history at the time, and the judge sentencing you was fully aware of that.
7-8 months in jail.
And if everything had happened, I guess normally, or in a way that we would expect, you would have been here before this court a long time ago, way before now, dealing with the violations. And just, like you are doing now, but they would have been a lot more timely. And the outcome of this would probably be substantially different. I don't think Mr. Thompson is exaggerating at all to say that, if you had come here timely and at that time back in 2009, the court likely would have imposed all the time that was remaining on your probation and likely would have given you the maximum sentence for the DUI. But we don't just pretend that these intervening 14 years didn't happen. You've clearly, everybody changes in 14 years, and your circumstances are no different. You've obviously been through a lot in your life, and some of those things are horribly negative, losing your wife. Some of those things are more positive. You've got these kids, and you appear to all, outward appearances to be doing quite well. So in some ways, non-traditional ways, maybe the goals of the deferred prosecution and the probation were met, but in an unexpected way, obviously. So I'm not going to ignore the things that have happened in the intervening 14 years that count in your favor. And I don't intend to be, excessively punitive because of that. But the other thing that I have to recognize is that there are legal requirements in sentencing for DUI offenses, as you know, and those can't be I'm somewhat constrained in the range of sentences that I can impose. So I will announce that here in just a moment, as soon as I calculate all the numbers. All right, Mr. Kalama, for the, I'm going to start with the deferred prosecution case. The first charge, driving under the influence, your sentence will be 364 days, 234 days suspended. That leaves, with credit for 1 day previously served when you were arrested, that leaves 209 days to serve, and that can be served the balance 89 days of total confinement and 120 days of electronic home monitoring. I'm authorizing the home monitoring, and you can serve that in any institution. So if you're able to serve that at Nisqually Corrections, if they're willing to do that, you could serve it there. Count 2, driving under the influence, will be a concurrent 90 days with credit for the day served. So you will serve and finish that at the same time. As far as financial obligations in that matter, it appears to me that a substantial amount have already been imposed as part of the DUI deferred prosecution, and you paid them all. So there will be no additional fines and costs imposed. This sentence, these two counts are concurrent with each other. However, they will be consecutive to the sentence that was previously imposed in your probation case. And I'm going to address that second. You're to start serving the time that I imposed here by January 2nd. And then once you complete that time, then the case will be closed. I don't intend for you to be on probation. On the probation case, which is C24354 TC, there were 185 days remaining in that case. I will revoke your suspended sentence and impose 30 of those days. And as I said, those are consecutive to the other sentence that I imposed. And those may again be served at any institution, and that would include Nisqually. I believe that all the time has already been served on count 2, driving while suspended, so I'm not going to address that any further. And once you complete this probation sanction, this matter will be closed too, and you'll no longer be on probation for that case. Okay. So, Mr. Clem, I know that's a significant sentence, and that's, you know, disruptive to your life and the life of your family. And I don't think there's any way to avoid that. I mean, anytime somebody gets sentenced to a jail sentence, that's a likely and normal outcome. But I do believe that this will recognize what the achievements and the rehabilitation that you've obtained yourself through your own efforts, without it being overly punitive in a way that would, I think, fail to recognize the accomplishments and rehabilitation that you've achieved. All right, so do you have any questions about this?
No. So I have to spend jail time then?
You do. There's 89 days minus
89
any
days.
good time that you get when you serve the time, and that good time's up to the correctional institution.
Okay. And then I just go, then I ask Nisqually, do I?
Yeah, you can approach Nisqually with this judgment. You can ask them if they're willing to confine you under it, and then they would report to the court when you complete it.
Okay.
Okay. And I don't think I mentioned, although we discussed it, that both counts of C579627 are dismissed, and so there's no sentence imposed under those.
Okay.
Okay. Mr. Compton, any questions?
Just one clarification. The 30 days imposed in the probation matter, is that to be served as confinement, physical confinement, or is the court imposing that as additional electronic home monitoring?
That can be served either way.
Okay.
I've indicated on the judgment that that can be total confinement or EHM, but in any case, it's consecutive.
Correct. So it would either be it would either be a total of 119 days physical confinement or a total of 150 days of home monitoring.
Right.
Thank you, Your Honor. That's my only
Okay.
question.